Right now, a murder trial resumes in which prosecutors say an obsessed lover, fueled by a jealous rage, committed a horrendous crime. Jodi Arias facing charges that she murdered her ex-boyfriend. But her defense team argues she acted only in self-defense. Arias and Travis Alexander met in 2006. They then broke up in 2007. But apparently they continued a physical relationship. And in 2008, a friend found Alexander's body. He'd been shot, slashed, and stabbed inside his Arizona home. Police photographs submitted as evidence captured a very gruesome scene. The court also heard earlier recordings of Arias telling investigators what she knew about Alexander's death, a story that changed several times.
What have you heard so far?
I heard that he passed away and that it was, I don't know, I've heard all kinds of rumors. I heard there was a lot of blood. I heard that his roommate found him or his friend found him or people were, I'm sorry. So I'm upset.
Ultimately, Arias confessed to killing Alexander, but only after he allegedly attacked her for damaging some of his possessions. If convicted, she could become the fourth woman on death row in Arizona. Let's talk about it with Fox News legal analyst Wiehl and criminal defense attorney Dwane Cates. Dwane, there's an awful lot of evidence against her here. Does she have a case?
Well, she does, and here's why. I mean, there are only two people in that room when this happened, and there's nobody else, and one of them's dead. So he can't tell any kind of story. So there's only two people in the room, and if she gets up and testifies that she was attacked, she might be able to justify what she did.
Her attorneys, Lisa, are saying, you know, this is a domestic violence case, abuse of a girlfriend. He was an abuser, they say, and he controlled her. You know, in the minds of a jury, might that stick? Might that mitigate some of what's...
I don't think so. Maybe mitigation, but then you're talking about sentencing at the sentencing phase after she's been found guilty. Right now, we're still at the trial stage, and here's why I say she's going to be found guilty. She changed her story. That is not consistent with self-defense. That you say first, oh, two men came in and abducted him, or it was suicidal, or something like that. And then she finally gets to the truth, which is, I killed him. Then she goes into self-defense. Well, then you go from her words, which were obviously not true the first two times, to then the crime scene. Here is a man who, I don't want to be too graphic, John, but was stabbed 27 plus times. His throat was slit. He was shot in the head. That is not self-defense. That is not consistent with self-defense. Self-defense is where you literally push someone back, stab someone once, run out of the house, call the cops, that kind of thing. What she's saying
but
now,
Lisa, it could be self-defense.
How can that be self-defense?
It could be self-defense. It could be self-defense in that she was the victim of domestic violence, and over the period of time he abused her, he verbally abused her. It built up into her to the point where when he attacked her, this rage came out of her, and she committed the crime, and she wanted to make sure that this man couldn't come after her. And she kept stabbing and stabbing and stabbing.
Okay, first of all, you know the law, which is imminent threat with domestic violence. You've got to have that imminent threat. And then you could only respond to the point of reducing that threat. To the point, 27 stab wounds, slitting the throat, shooting someone. No, I don't think a jury is going to buy that that was self-defense. And the fact that she already told many fabrications to cops and to TV and to everybody else. And then she finally comes forward. When? Only when the forensics came to light.
Well, but at least the evidence in this case, is that there was a major struggle. There was blood all over this bedroom. One stab wasn't going to stop this man. He was a big, strong man. There was an epic struggle in that bedroom, and self-defense.
And she's the one with the gun. Come on.
Well, I guess that's why attorneys like to argue in court, because it's been a pretty good argument here on television. We're going to continue to follow the new developments in that trial. Jodi Arias could go to death row in Arizona. Meanwhile, day 2 of a preliminary hearing in another high-profile murder case about to get underway. This one involves the gunman charged with going on that deadly rampage inside a movie theater in Aurora, Colorado. Lisa and Dwane will be back with us shortly to give us their legal perspective, including whether James Holmes will actually go on trial. But first, Rick has the latest update on that case. Rick?
Well, John, the point of this hearing is to determine whether there's enough evidence to go to trial. And the judge has set aside at least 5 days for prosecutors to lay out their case. And the defense may also call witnesses as well. Day one was tough. There were family members of the victims inside the courtroom. They heard testimony from the pathologists who did the autopsies on the victims, 12 of them. But perhaps the most difficult words to hear came from the first responders, police officers who described what it was like inside that blood-soaked movie theater. Other officers telling stories of finding the youngest victim, a 6-year-old with no pulse, of rushing gunshot victims to the hospital, and of keeping one of them, a dad, from leaping out of a moving patrol car as he tried to get back to the scene to find his 7-year-old daughter. The next few days of this hearing, John, will also determine whether or not, as you mentioned, James Holmes is fit to stand trial. He sat in the courtroom yesterday emotionless, much the same way as he was described at the time that he was apprehended behind the movie theater right after the massacre. His public defender has not said whether he plans to use an insanity defense. Back to you.
All right, let's bring back Lise Wiehl, our Fox News legal analyst and criminal defense attorney Dwane Cates. Lise, it doesn't really sound like this case lacks for evidence against James Holmes, but it is going to be all about the status of his brain at the time. Was he sane? If a guy is sitting there in court emotionless, listening to this kind of testimony, does that ultimately help prove insanity?
It does not help prove insanity at all, because what it has to prove insanity, the defense has to show that at the time of the alleged crime, he did not know right from wrong. And what the prosecution is showing in this very extended preliminary hearing, I've never actually heard of one going on so long, actually a whole week, is that he knew, he premeditated this. He had booby-trapped his apartment. He had everything all set up. He'd been buying the guns on the internet for months before, or weeks before. So he knew what he was doing. He knew right from wrong. So that will not lend itself to an insanity defense, and let alone an incompetency defense.
What about that, Dwane? Because there are also reports that he, sent his a psychiatrist who had been treating him. He had sent to her this notebook that contains sketches of this, kind of heinous crime. Doesn't that show premeditation?
Well, it might show premeditation, but it doesn't show that he knew right from wrong. I mean, just because you're buying guns on the internet doesn't show that you know you're wrong. Just because you send something to your psychiatrist saying that this is going to happen doesn't mean that you know that you're wrong. This is going to come down to expert witnesses. They've got to get some psychiatrists and some psychologists involved. They've got to do some testing, and they got to come up with whether or not he was, number one, whether he's competent to stand trial now, and whether he understood the difference between right and wrong at the time of the commission of this crime.
With all due respect to the experts, you know that both sides, both prosecution and defense, will come up with their own experts who will say exactly the opposite thing. It will come down to the jury, if it ever gets to a jury. My inclination on this, John, is this is a slow, long guilty plea here in this preliminary hearing, that it'll probably never get to a jury verdict, that the prosecution may take the death penalty off the table and say life in prison without possibility of parole and get this over with.
But the victims are going to have a voice in that, right?
Of course, and they'll have allocution, absolutely.
All right, Lise Wiehl, Dwane Cates, we're going to leave it there. Thank you both.